for questions and answers, about 15 minutes or so for any questions. Yes, Ed?
Do you provide your clients customized lease?
I can, yes. Some clients prefer that over the poor lease that they got from Office Depot. Hey, Office Depot's great, but they don't do a good lease. I can tell you, and it doesn't comply with Texas law. If you're using an Office Depot lease, it is so generic on purpose so that it applies to all of the states, but it does not cover the specifics of a Texas lease. Don't use a generic lease that doesn't address Texas law. Yes. Texas law. Yes, ma'am.
Yeah, the background check, if someone had like either outgo or that like over 20 years ago, and say, well, I was young. Would you accept this tenant or?
So she's asking, what if someone has a misdemeanor or even some felony that's more than 10 years old? So this is where you have to have what I refer to as a tenant scorecard. And so one of the tools that I offer to landlords is this thing called a tenant scorecard. And in your tenant scorecard, you predetermine what you can stomach. And it's like, well, if it had been one murder, I'd have gone for it, but two, no, that's where I draw the line. You know, so you have to determine what makes sense for you. If it's some misdemeanor, nonviolent crime, you know, it's a little bit of pot, more than 5 years ago, you have to say, I'm fine with that. Or if you're like, no, I'm staunchly against all drug use, that's fine too. And so, but you have to use the standard for everybody. You can't say, well, when these people apply, I use this. Or when that age group applies, I got to use this standard. Or when people from this socioeconomic part of the country come, I got to use this standard. You're asking for a federal lawsuit if that's the case, right? And so if you use the same standard for all people, you're probably, as long as it doesn't in and of itself discriminate against race or country of origin or, you know, nationality, that sort of thing.
Yeah, if someone is not on the application, it's not on the application, then you pick this person, right?
Depends what your lease says. I hope your lease says this tenancy is limited to the named tenants and the named occupants and nobody else. That a guest who stays more than X number of days is an unauthorized occupant. And so your lease should already address that, and so your notice to vacate or your notice of default should address that as soon as you know it. Again, we practice a 7-day rule with all breaches, and so you send in the notice, you got 7 days to fix this, otherwise this is going to be a problem that might lead to, and I appreciate that you have a lot of questions. I'm going to jump to the gentleman in the back.
We also include the specific pet names and the pets themselves.
Mm-hmm.
You had a case where a dog died, and I was allowed a dog, and now there's this force in there.
Mm-hmm. It gets worse when they have an emotional support armadillo. You know, it's like, well, my dog's gone, but Army here makes me feel good. And so you can't charge for that, right? If there's a legitimate medical need and they have some legitimate basis for saying that this is an emotional support animal, that's not a pet. And so that's something else to consider. But yes, if they've paid a pet fee, it's not interchangeable. It is specific to that one pet, and you should identify the pet. There are even pet screeners, right? Believe it or not, some screening companies who screen tenants also screen for pets, right? Because what if that pet is prone to biting, right? What if that pet doesn't have his rabies shot? You want to know what happens if somebody gets rabies from a pet bite at your property? Guess who's getting sued? You are, right? And if that animal doesn't comport with your insurance, guess who might have to pay for the full cost of that claim? Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. Yes, JK.
I'm a broker and an appraiser, and I'm kind of sleepy. But somewhere I thought you had to have like a criteria to show the tenants first, like no pit bulls, no blah blah blah. can't discriminate, obviously, but you have to kind of show them ahead.
If you've prepared it, you can show them, especially if they ask, right? Not everybody asks, but it's helpful. You know, some people call this the weed out process, right? And so if someone is an interested applicant, you send out the criteria and say, these are the standards that I'm seeking. If you qualify, hit me up. Send me an email, give me a call, that sort of thing. And so this right here is kind of pre-screening, right? Now, you have to do the legwork to confirm that this applies, but yes, it is helpful to have this tenant scorecard because in this case, you can pre-screen people who are like, oh, that's not me, that's not me, that's not me, whoo, that's definitely not me. I won't even bother, right? Yes, sir.
Okay, speaking about pets, you just mentioned that. I was thinking, can I just avoid the problem altogether and just have my contract, no pets allowed, period?
Sure,
Okay.
but you can't exclude emotional support animals or service animals.
And so how is that, I mean, how do you get past that?
You stop leasing. Yeah. Because it's a federally protected, it's like saying, wait a minute, you take asthma medication? Pfft, I'm not about that. You know, the federal government has deemed this a legitimate medical tool, right? So again, it's not a pet at this point. You know, you're gonna tell a blind person they can't have their seeing eye dog? You know, federal offense. You know, you're gonna get a civil lawsuit. Yeah, if you want out, you can get out, absolutely. Yeah.
That's a workaround.
So what I recommend to landlords is to not ask about pets. You always want to ask about animals in your application. Are there any animals that you plan to bring onto the property? Got to be real careful with what we say here and how we do it, because you cannot discriminate against somebody because of their medical needs. But if they are not the most qualified applicant and they are disqualified on some other basis, pass them over, right? You want the most qualified applicant that you find who comports with this. And generally speaking, if they don't meet every one of your criteria and you have high standards, because of some other reason, you can definitely pass them by because they don't meet that standard. Yes, ma'am.
So is there a document that you have to prove that that's service animal?
There is not. It's complicated because they're currently, so this is a brand new thing in the law, right? And so when the law changes, it makes things complicated for people in practice. It makes things complicated for the courts because, yes, so the law says something and then it says, and you guys deal with it. And so now courts are having to make these rules up on the fly. And so here's what the current understanding is. Because there is no body that draws a bright line, except for the seeing eye dog. That's an absolute. If someone has a condition that is open and obvious, like blindness or paralysis, it's open and obvious, and they have a certified service animal, which can only be a dog. You cannot have a seeing eye cat. So it's only a dog. If they have that, they're in, no questions asked, right? But there are certain conditions where a dog even can detect an oncoming seizure. Now, somebody who is prone to seizures, that's not open and obvious, right? You know, well, show me. Have one right now. I'm like, oh, yeah, you know, can't do that. And so that would require two things. It would likely require some documentation from a medical professional, their doctor, and additional documentation, and it could be from the same doctor, that states, number one, they have this condition. Number two, this particular pet serves this particular function. Without both, you don't have a qualified service animal. The same is true of an emotional support animal. If someone has an emotional disability and they have documentation from a trained medical professional who can attest that they need this and that this specific animal serves this function, that passes the test. If they're missing one or the other, they are still not in compliance. And we don't know that this is a legitimate animal for this purpose. Okay.
For
build Fred's question. So if you have a lease that doesn't allow pets, and then an accident happens when you acquire the pet later, and then it bites somebody,
Yeah.
what happens?
So your,
To the landlord.
yeah, so your lease should have an indemnity clause that should indemnify you in this case. And indemnity has to do with them stepping in and saying, I'll cover this. It's my bad. I'll cover indemnity. But that doesn't mean that they're not going to come after you. That should be a good defense to you. But ultimately, a court may have put a duty on you to go and inspect and say, look, you had access to go check this place out. And if you didn't, you didn't give reasonable care, you should have known that this was there. And because you didn't, I don't care about that indemnity clause. You're on this lawsuit. And so we're not talking about inspections, but that's one really great reason why you should have routine inspections. I recommend 2 per year. One at the 3-month in a year lease, and one at the 9-month. The 3 and the 9. And there's also something you go over in your talk before you hand over the keys. I got time for about 2 more questions.
Have you had a scenario where someone might claim that they have multiple dogs, like 2 or 3 dogs, that they're all service dogs? It hadn't happened to me, but I know someone who's had like a whole horde of dogs.
Right, because the whole family is emotionally dependent. I mean, funny as it might sound, it is mathematically possible that each of them has a letter from their professionals, and that yes, it is mathematically possible that this could occur. I've never actually seen it. I've seen where all of a sudden somebody makes a claim. I had a funny one, where a young lady made the claim that her dad's emotional support animal was now supporting her emotionally. So he passed one test, which was a doctor said that's what he serves as. The problem is, man, it was real convenient, the timing, because it was right as her dad was moving to another state. And so it suddenly became her emotion. So we challenged that one. We challenged that one, and I can't get too far into that one, but yeah, it happens. People will make stuff up all the time. Okay, last question, Thomas.
Okay, got a question for you, critique existing lease. I have one that says I got to cut the grass, $300, but I have to come in and do something.
I can, and so like I'll offer a 30-minute consultation in my office in which I can look at whatever document, your lease, your notice forms, your application process, whatever. Yes, and sometimes people will come to me and say, you know what, this lease is just terrible. I've been burned so many times, and sometimes it's not the lease's problem. And many times landlords get themselves into trouble with the special provisions portion of their lease because they get real creative with special provisions and like, yes, I can come in on Thursday and I can use your shower. Like, what? Like, no, that doesn't make sense. Don't do that. And so they'll get a little too creative where that's concerned. And so, yes, to answer your question, we do review leases and then counsel clients as to whether or not they do need an improvement or maybe they need an update because they've been using it since '75. And so it's probably a good idea to revamp it because the laws have changed. Yeah. Joe, I know you had a quick question, so this will be the last one.
In situations when there will be landlord takes tenant to court,
Brass knuckles. It's hard. There are a couple of mechanisms. I'll touch them just very briefly. If you have a reasonable expectation, they'll be able to pay, right? They just came on hard times, but otherwise they make a good living. Or you know that they own property, perhaps. Maybe they share co-ownership with their brother in a vacant lot or something like that. Or you know they have a pretty healthy bank account. They were just stubbornly not paying for some reason. That happens. If you have a reasonable expectation, you can abstract the judgment that you get from them, put it on their credit, make it a judgment lien. You'll need certain identifiers to do that. Date of birth, social security number, Texas driver's license, which you probably and should have gotten in the application process. And so you can abstract the judgment. If there are if there is non-exempt property from which that can be seized to pay your judgment, then you get what's called a writ of execution, and the constables will go and seize that property and hold a constable sale, and the proceeds of that sale will go to pay off the judgment. If that's not the case, then sometimes just having the judgment abstracted years down the line serves you, because maybe their financial situation has changed and now they want to buy a house. But the title company does a search, and because you diligently abstracted your judgment, they come across this judgment lien, and then they're giving you a call and saying, hey Joel, these guys really want to buy this house, but they got this $6,000 judgment, which has grown with interest over the last 5 years, and they want to pay it off so that they can get this loan. Where can we send a check? Right? And so it's always helpful if you have a judgment against a tenant to abstract it, to make sure that you have these identifiers, so that maybe down the line you can either A, go with a writ of execution to seize non-exempt property, or B, further down the line, get a phone call to clear out this judgment because they want to buy a house.